Good afternoon, everybody. My name is Andrew Zwerling. I'm here with my partner, Kevin Donahue. We're partners at Garfunkel Wild PC. Glad to not literally see all of you, but judging from the number of registrants, there's plenty of you watching at this time. Today's topic, understanding and avoiding claims under the Americans with Disabilities Act. Before I get started with Kevin on some of the substantive matter, just by way of quick background, Kevin and I collectively have over 60 years of experience as litigation attorneys. We're members of our firm's litigation practice group, but more importantly for today, our employment law practice group. It's a fairly robust practice group in its own right. Kevin and I have been handling cases involving these issues on many occasions: discrimination cases, disability discrimination cases, website access cases, and so on. But Kevin and I are somewhat different than the average litigator in that we wear two hats. We're litigation attorneys, trial attorneys, but we're also employment attorneys who counsel clients on myriad issues on a day-to-day. And as litigation attorneys, we're able to see at the back end, after a complaint's been filed, how a client has handled something correctly or perhaps less so correctly. We're able to see whether a client acted in a compliant fashion, proper fashion, and if so, was the right documentation in place. And then we use that information to guide us on our day-to-day in counseling many of you. Before we get started on some of the substantive matter, I just want to stress that even though this is a webinar, you do have an ability to type questions to us. We'll do our best to answer them as the program goes on. We're fine with taking questions on the fly rather than even waiting at the end. Just one thing about our firm, again, judging from the registration list, many of you have worked with Kevin and me over the years anyway, so you know about us. Just one change that many people may not be aware of is this year we opened up an office in Florida as well, as far as what's new and different at Garfunkel Wild. So what are we going to talk about today? The next slide over. What are we going to discuss? In terms of our agenda items here, patient disability access issues. And those take many different forms, as some of you, judging from the work we've done with you, have experienced. It could be physical access issues that Kevin and I are going to talk about. It could involve anywhere from the number of handicapped parking spots, the width of those spots, the number of cutouts on a sidewalk, wheelchair access issues, and so on. It can be language barriers. Communication barriers of various descriptions involving whether someone's limited English proficiency or hard of hearing patients, and so on and so forth. And we're going to walk through what are your obligations as a provider, what changes, if any, have to be made to your policies and procedures, and so on. Website disability access issues. How good is your website, not simply in terms of the content that's imparted, to help drive the delivery of services, but how compliant is your website with regard to people who are visually impaired and the like. What are the standards that I'm going to be held by? What can I do to make my website proper? What should I be doing now if I haven't done it? Because you don't want to wait for a lawsuit. There's been a surge probably in the last 8 to 10 years, and it's climbing, and we'll get into that in a little bit, of litigations involving these issues. You read in the newspapers, and some of us as litigation attorneys have seen some of the same names popping up, not just the lawyers, but the plaintiffs themselves. A serial plaintiff who will use a wheelchair, go into a facility, and if the towel bar in the bathroom is too high or low, poof, you got a code violation, and go from facility to facility. You'll get the same plaintiff in these website access cases suing 20 different entities, claiming that he or she wanted to seek medical services at a facility and allegedly couldn't because of website access issues. Our goal here is really just to arm you with an awareness of these issues, so that you can take preventive measures that should prove helpful in keeping you from being targeted, or should prove helpful if you are targeted in a lawsuit in defending that lawsuit. So next slide over. What do we mean by providing meaningful access? You have a host of laws, codified law, for example, that are there to make sure that limited English proficiency and deaf and hard of hearing patients are provided meaningful access to salient information concerning their health care and well-being. And what you see on the slide there is just, it's not an all-inclusive list. Title VI of the Civil Rights Act. You have national standards on culturally and linguistically appropriate services. The American with Disabilities Act, the ADA. The Hill-Burton Act, Section 1557 of the ACA. You have state laws, you have city laws, you have county laws. Creates quite the murky landscape, in trying to navigate, if you're a provider, a healthcare provider. And we're going to walk through what some of those standards are, not in high legal fashion, but enough to acquaint you with what those thresholds are that you have to satisfy and how to satisfy them and navigate them with as little problems as possible. So the starting point, the ADA. It's over 30 years old. It's been around for a while. You see some of the major components on the screen. You have Title I, discrimination in employment. A big one, Title III, where a lot of these cases flow through, discrimination by public accommodation. And as I mentioned before, and we're throwing Connecticut on there, Jersey, we're really focusing on the tri-state area when Kevin and I address these issues, because you have a lot of overlap between federal, state, and city law. But as you get more granular, especially, for example, New York City, there are much broader protections for individuals with regard to disability discrimination and the issues we're going to cover. And you need to be aware of them, wherever you're located. In terms of the ADA, it's the main law regarding disability access and the prevention of disability discrimination. The ADA works hand in hand with Section 504 of the Rehabilitation Act and essentially prohibits entities, including healthcare providers, from denying individuals with disabilities participation in or access to their services, or otherwise subjecting them to discrimination solely by reason of their disability. And as I mentioned, because the standards of liability for claims under the ADA and the Rehabilitation Act are essentially the same, courts compress those issues and the analysis of those issues and treat them together, because they, again, both essentially prohibit healthcare providers from denying individuals their accommodations, advantages, facilities, or privileges on the basis of, in part, and what we're talking about today, disability. But again, remember, the federal, the ADA, the Rehabilitation Act, even the New York State human rights law, they provide a floor for what you have to meet. There are local standards that are going to raise that bar. So what are your obligations? As you see on the screen, in general form, it's illegal for any business, healthcare entity, facility, building, or other place that's open to the public to discriminate against people with disabilities. And as I mentioned before, this is a heavy reliance on Title III, the public accommodations component of the ADA. But it doesn't simply bar discriminatory conduct. As Kevin's going to go into more detail on the reasonable accommodations issues, you have to take steps in advance before someone walks in the door, so to speak, to eliminate those issues or barriers that are going to impede that individual, that patient with disabilities, from fully enjoying the services that you're going to provide as a healthcare provider. If you don't provide those accommodations, and we're a real believer as litigation attorneys, take that, implement those preventive measures sooner than later, you're going to have a hard go of it should you be named in a lawsuit. As if all those laws weren't enough, as the next slide will reveal to you, you also have Section 1557 of the Affordable Care Act, which is going on 6 years as of 2022. It actually extended those protections to individuals participating in, and you see the bullets there, but the essential piece of the ACA, it applies, as you can see in the bottom, to facilities who are receiving federal funding. And in particular, there's a heavy requirement placed on hospitals for that reason. Obviously not every healthcare provider receives federal funding, but many of you do. So this is an extra layer of requirement. In terms of the obligations, and its essence, provide meaningful access to each LEP, limited English proficiency individual, to be served or likely to be encountered in your healthcare program or activity. Examples of that, and these are only examples, there's a lengthy list. You have to offer a qualified interpreter when oral interpretation is a reasonable step to provide an individual with meaningful access. What does that mean? Well, it's a pretty broad statement. Kevin and I are going to go into more detail about what that means, because each one of these cases is very factual in nature and whether or not reasonable steps have been implemented. Provide the language services free of charge and in a timely manner. Again, someone is experiencing substantial delay in receiving medical treatment because you don't have the right language services available. That can create an issue for you as well. Adhere to certain quality standards in delivering those services. So for example, if an interpreter is there, does he or she meet the qualifications of competency as an interpreter? And we'll talk again more about that as well. So Kevin's going to talk to you, as I mentioned, about some of the reasonable accommodations that we're referring to under the ADA.
Thank you, Andy. Hi, everyone. I'm Kevin Donahue from Garfunkel. I appreciate your time today. The types of reasonable accommodations that you're looking for, depend on the type of case. During this program today, during this presentation, we're really going to focus on the three main areas that these cases pop up and that the ADA cases come up. They come up with regard to providing interpretation services to limited English proficiency individuals or those who are deaf or hard of hearing. So you have the interpreter cases. You also have cases with regard to access, ingress, egress to a building or when you're in the building. And those are kind of seen as physical barrier cases, and we'll talk about that. And then also website accessibility cases. So those are the three areas that we're seeing a proliferation of lawsuits. Basically, the first wave of those cases was the barrier cases. Actually, those were in the 90s into the 2000s. Then you started seeing more and more interpretation cases crop up. And now in most recent years, probably the last 3 or 4 years, there's been a huge uptick, as we'll tell you during the presentation today, in website accessibility cases, basically with individuals who are visually impaired and their attempts to try to access information and have the access to the portal of your website. So what do you have to do with regard to accommodations? The statute talks about reasonable accommodations. The first thing you have to do is you have to review your policies and procedures internally. And as Andy mentioned earlier, this is not only, the statute's not only meant to prevent proactive discrimination by individuals, but it's also, you're supposed to be thinking about things ahead of time and being planning for those segments of the patient population that you're going to service. So what does that mean? Well, with regard to the deaf and the hard of hearing community, or with regard to people who have limited English proficiency, you have to be able to provide them with translators. And with the deaf or hard of hearing community, you have to provide them with auxiliary aids, such as if you can't get an interpreter, you have to do VRI, which is remote video interpretation. And then we will talk about architectural barriers. So with regard to giving equal access, the gold standard at the end of the day, and what you're shooting for, and it's both what you're shooting for as a provider, but also what will put you in good stead if and when there's ever a legal challenge or there's a lawsuit or a claim that's made, is effective communication. So at the end of the day, you want to ensure, and so that way, if there ever is an issue that comes up, whether or not you were able to effectively communicate with the patient about their medical condition, about their treatment, and about their prognosis. All too often, these cases crop up, and a patient will come forward, and sometimes you see them twin. They're in tandem with a medical malpractice claim, but very often they're not with a medical malpractice claim. They're just a standalone ADA case that says, "Look, I went in, the care wound up being okay, so they did a good job as a clinician. However, at the end of the day, I really didn't know what was going on, or they didn't communicate with me, or so hence I don't want to pay this bill right now, or hence I'm nervous and concerned about my welfare going forward." And we hear this time and time again. So in order to provide equal access to this goods, to the services that you're providing at your healthcare facility, you got to provide auxiliary aids. Now, what could serve as an auxiliary aid? Well, if you write down something or take notes, or if you type something on a computer screen, those are all helpful. However, that's not what you really want. At the end of the day, what you want is you want to have an interpreter. All right, you want to either get an interpreter in person, or you want to have one provide interpretation services remotely. One question we get, and there's a note here on the screen, it says it's not a 24/7 obligation. It's not. A lot of our clients come to us and say, well, I can't have a qualified interpreter on staff all the time, or, what am I going to do? I have to pay for this, or, and the answer is no. But you have to have systems in place and policies and procedures in place that you look for the need for interpretation for your patients, and that you're able to meet that need with reasonable notice by the patient or reasonable notice by you to the interpreter, that he or she can come down and provide interpretation services. As we were just talking about, so auxiliary aids and services would be qualified interpreters, note takers, or written materials. Again, it's an effective communication standard, and it's also a standard where at the end of the day, and we're going to talk about this a little later on, that you want to show that you're grounded in reality, and then you're not deliberately indifferent with regard to the needs that the community requires in order to receive the benefit of your services. So if someone's deaf or hard of hearing, that the gold standard there would be to get them an interpreter, and to get them a live interpreter. So what do you have to do? You have to, at the outset, you have to have your intake and support personnel that are going to be setting up appointments. They're going to have to ask and find out whether or not someone needs interpretation services. If they do, you have to call ahead and you have to make sure that the interpreter is going to be there at the time of the appointment. If that doesn't happen and someone comes in and surprises you with it, you have to have policies and procedures in place, which both include the practical nuts and bolts of what phone number do you have, what service do you reach out to, how do you do that, and also what's the chain of command within the office. Andy and I have had the privilege of litigating numerous of these cases, and inevitably we wind up going to depositions all the time, and they say, okay, well, who did you call? What was the phone number? What was the, did you determine that in advance? Where's the policy and procedure that you had in advance that was set up for this? And we can beat back these cases much more effectively on your behalf when there are policies and procedures in place, and when you try to provide those auxiliary aids and services to provide effective communication to the individuals. But again, the gold standard is to get an interpreter, and you even see here, Health and Human Services has said that it's extremely difficult for a healthcare provider to demonstrate in certain settings effective communication in the absence of an interpreter. So
I'm just going to interject, Kevin, just a couple of comments, and then I'm going to tie it into a question that's been posed. As Kevin is saying, err on the side of providing more, which means an interpreter. When in doubt, provide an interpreter. That said, although healthcare providers should consult with hard of hearing or deaf individuals as to their preferred auxiliary aid or service, the ultimate decision rests with the healthcare provider, provided it results in effective communication. Because courts have held that have also held, and this is a caveat, a helpful caveat to that, effective communication, as Kevin pointed out, is a practical standard and doesn't require perfect communication. So you as the healthcare provider are ultimately the final arbiter of what services are to be provided, which segues into the question being posed, which is, if a patient requests a specific interpreter, do we have to provide that interpreter? The answer is maybe, because it's going to depend upon whether or not you can document and that you have faith that that individual is qualified to serve as an interpreter. So a family member may serve as an interpreter, but if there are doubts about competency, if there are doubts about confidentiality being maintained and so on, and Kevin will talk about that, you don't have to. Kevin?
Thanks, Andy. It also brings up the idea, and we'll get to it in a couple of slides, is that when you're doing interpretation, there are people that speak different sign languages, and also have different levels of being capable of signing. So we'll speak a little more about that. Who's a qualified interpreter? There are certified interpreters that can be provided, but the legal standard is anyone that's able to interpret effectively, accurately, and impartially both receptively and expressively, meaning that they can both impart information and receive information, using any necessary specialized vocabulary. And that's important when you do line up interpretation services, as you are a healthcare provider. There are certain interpreters that are that work with physicians and their staff and technicians and stuff, and they're more facile with medical terms, and you want to make sure that you do have an interpreter that's going to be able to assist in those situations. One note here, whether or not you can use family members. We have had many cases where someone has said, "Oh, don't worry about it. I'll use my family member." They're generally not considered appropriate interpreters because of their emotional involvement and because of their personal involvement. And also, too, you wind up losing confidentiality, the doctor-patient privilege. That being said, if that's your only interpreter that's available and you document the record at that time, we have had cases where, someone said you can't get an interpreter, you're writing notes, you're otherwise typing, you're trying to communicate as effectively as possible, and someone says, "Oh, let me just bring my daughter in, or let me bring my father or mother in, they can help." You have to, at that point, if that does happen, and again, that shouldn't be what you're looking for. You're looking to get an independent third-party interpreter who can come in, who can assist. But if that does wind up happening, you do want to let the patient know and ask them, are they comfortable with this? Do they understand, and that you're not looking to enlist their family members to interpret, but under the circumstances, you'll allow it. And always document that in the chart.
And just as an example of what Kevin's talking about, Kevin and I had one of these cases. Person was in the hospital for a bunch of days. A family member interpreted. No reason to believe there was any problem in terms of effective communication. It was admitted that the family was very gracious and grateful to the nurses and the staff and so on. The minute the person gets out of the hospital, boom, they file a lawsuit. I needed an interpreter. And there were multiple affidavits filed by family members talking about how their loved one, and they personally requested an interpreter. The staff, when we went in and spoke to people, said it was nonsense. I'm being polite in my choice of language, but there wasn't documentation. And it became a real gaping hole in the ability to defend. You don't have the documentation, he said, she said, you're going to have problems. But it just highlights what Kevin is saying about the risks associated with using a family member. Thanks, Kevin.
Definitely avoid using family members. We also had another case where the optics were actually terrible for our client. They enlisted the support of a minor child who at the time was only about 7 or 8 years old, and the parent who they were interpreting for wound up had sustained a very severe injury that ultimately had some bad outcome. And the idea that it came across at the time to the mediator and to the judge in the case as callous, that anyone would think that a 7 or 8 year old minor would be an appropriate person to speak about such serious medical issues. Not only do they not have the vocabulary, but obviously they're the pinnacle of what you would be looking at in terms of emotional investment and being personally related to the matter. The key interactions when you are looking for effective communication, obviously discussing the patient's medical condition, their symptoms, their history. While a lot of times people say, well, how did you diagnose me, or how did you let me know what the prognosis was? There are people that, again, when we go to these depositions and we fight these cases, they say, how did you get the name and address of this person? How did you find out what their medical history was? What was the type of communication that you had during those times? So you do need effective communication, it basically from beginning to end of whatever the typical visit would be or the typical patient interaction would be. You want to make sure that you have effective communication at every step of the way. Obviously, when you get informed consent, that's absolutely critical. And when they're providing the informed consent, many times you are looking to get not only a verbal, but sometimes you have them sign something. Speaking with them about it and making sure that they understand what they're signing. And then explaining anything with regard to medications, aftercare or discharge, or or following up with regard to billing and collections. The billing and collections and the insurance issues is actually a little more of a novel one. We usually get it on the clinical side where the patients, are more, because I think a lot of patients have less of a concern about the payment issue, but increasingly more and more now patients are coming forward and saying, well, I didn't even know, I didn't want to pay for this, and they didn't communicate it to me because the interpreter wasn't there, wasn't present. So make sure that the interpreter is used not only for when you're rendering the medical care, but to the extent possible, if they can speak to them also about billing and collection type issues and insurance issues, that's definitely worthwhile. As we mentioned before, there are different types of sign language. The most common form of sign language is American Sign Language. It's actually not based on English, but it's based on French. But then there are other language systems. Most qualified interpreters or certified interpreters are able to sign with people that through ASL, is the American Sign Language, or through Sign English. But there are also sometimes more grassroots ways of dealing with people that are in the deaf or hard of hearing community. In the most extreme circumstances, if the person is a very low functioning in terms of their ability to sign, there are instances where you might have to get a certified deaf interpreter, which is known as a relay interpreter. So that way that the patient that you're providing the services to can deal with the certified deaf interpreter, and then that interpreter then in turn speaks to yet another interpreter that then translates for you. Those are rare instances, but but they come up if the person's really never formally been trained in ASL, or if they have other cognitive issues or other sort of any other disability. A VRI, video remote interpreting. That's my last slide before I hand it back over to Andy. What are the pros? What are the cons to it? What is it? What it is it's essentially giving somebody either a laptop or a tablet or something some sort of screen that's connected to the internet. It's a high-speed connection with that has as seamless connection as possible, where there's someone on the other end that is an interpreter, and it could be both for limited English proficiency purposes, for different languages, and also for sign language. And that person interprets. You basically show the screen what's going on in the room to that person. They receive the information, they interpret, and then it comes back to everyone through the screen. We are counseling all of our clients to have this as a backup. So in an ideal situation, you want to, and the policies and procedures, and we work with people on this, both in the, on the employment side. So it's something that's a service we provide. We set it up to the gold standard. You're going to try to get an interpreter to help you. However, if you don't, then you have, the backup can be VRI. Some of our clients rely entirely on VRI, and then when we litigate those cases, at times, it is seen as enough. Other times, people say, well, what efforts did you take to get a live interpreter there? So be aware of the fact that the live interpreter is still a gold standard, but VRI is a great backup. And then if and when we do litigate these cases, it's great to be able to go in and say, we had a policy and procedure. Here's the company that we typically use for live interpretation services. By the way, when they're not available, they can't send someone and meet our requirements. We also have VRI set up through a certain website or through another service. And it makes you look like you're grounded in reality. It also makes it look like you care, because you do care about complying with the law and about appropriately and fully servicing this part of the patient population. Now I'll turn it back over to Andy.
I'll talk about this slide, but then I'm going to answer a question that's on the screen. VRI contraindications. Well, VRI is not always going to be effective in all circumstances. For example, it will not be effective if the person who needs the interpreter has difficulty in seeing the screen, either because of vision loss or because he or she cannot be properly positioned to see the screen because of an injury. Maybe they have to lay in a prone position and they can't sit up, or some other medical condition. And in these circumstances, an on-site interpreter may be required. I'm not going to say must, because again, it's a sliding scale factually about what is needed or not needed in a given instance. But when in doubt, use an interpreter, which kind of ties into the question that we were posed. I'll read it to everybody. We have a deaf patient who's getting weekly allergy injections. She's requesting an in-person interpreter for each weekly visit. The cost of this is much more than what we make on the allergy injections. Since she is requesting an in-person interpreter versus using written communications, do we absolutely need to abide by this request? We have offered to use a whiteboard to communicate and to have a nurse sit with her the whole time she's here. Is there any way of getting around this? Obviously, we can't give legal advice in a webinar. We all understand that. That said, but I'm going to speak more in the hypothetical, which is, remember the points Kevin and I have made. And I'm going to answer the question in terms of the essence, right? Which is the healthcare provider is the final arbiter of what service is going to be provided. And so long as you as the healthcare provider have faith in the method by which you're going to provide that effective communication, and you have a solid basis for having that belief, that's documented. You need both solid basis that's somewhere in the record. Then you get to decide. And obviously, there's risks associated with whatever path you take, but there's risks that are worth taking at the end of the day. If in your judgment you're providing whatever is needed for that person to understand what the treatment involves and all of those variables that Kevin went into just before about what needs to be communicated to a patient. So if someone's only coming in for a flu shot, they're going to need less in terms of the method. They didn't need an interpreter versus someone who is just come out of a surgery and is going to be laid up in a hospital for a couple of weeks, is on medications and is going to go through rehab. There's a whole lot more detail that has to be communicated. So I'm using a flu shot as an example. You don't need an interpreter for someone to walk in and get a flu shot, but you still want to ensure that the method you're using, if you're going to use written communication, for example, it could be handwritten notes, it could be texting the individual, right? You want to make sure that it's their primary language, because we've had that too, where all of a sudden, there's the assumption, and that's always dangerous, right? The assumption, well, I'm able to communicate somewhat with that person. I think they're getting it. You want to walk away confident that they do understand that the language you're communicating in is their primary language, and then you don't have to have an interpreter in your given instance, whatever that instance may be. But again, do you have faith that you're effectively communicating based upon the issues at stake and that need to be discussed between you and the patient? And then are you documenting it? All right. Next slide, Kevin. I'm going to go through these next 4 slides a little bit more quickly because we still have a lot of ground to cover. But within its mandate of providing meaningful access to each LEP individual to be served or likely to be served by a healthcare provider, at your facility, there's been updates to the ACA in the last several years, and you have this 4-factor test that you see up on the screen to determine whether or not you as a healthcare provider are being compliant. I mean, you can read the slides, but those are the variables that are going to be considered, because, for example, you don't have to have 20 interpreters waiting on site. If your medical practice or facility historically only sees 1 or 2 deaf or hard of hearing patients a year. So it's going to be factual what you need or don't. Obviously, if you're a hospital with tens of thousands of patients flowing in, the requirements or expectations of you as an entity are going to be different than a solo practitioner. So that's the sliding scale, taking into account those variables. The updates also eliminate the need in terms of the definition of a qualified interpreter and who's a qualified translator. But that said, as the next slide points out, it amplifies certain points that Kevin was making earlier. There are still minimum thresholds in terms of competency that interpreters and translators have to hit, which again, tying it back, you can use family members, but there's a heavier risk once you do for the reasons Kevin shared with you. And there are standard, generally accepted interpreter ethics principles. The client confidentiality piece is a big one as well. How proficient are they? And again, there's myriad languages that you're going to be confronted by. That's going to be a factor into what the demands are on you as a healthcare provider. We're going to move to the next slide, actually. We can skip this one for the sake of expediency. A significant one here is, many of you may remember back in 2016 when Section 1557 hit, that for a lot of your notices, you had to post the taglines in the top 15 languages that your medical practice encountered historically. It was a pretty onerous requirement. It was well-intentioned, right? But it placed pretty, heavy burdens on facilities and so on. That has since been removed. So I just figured that was worth highlighting. Kevin?
Next type of case, so we just spent a lot of time talking about interpreters. I want to move on to architectural barriers. Architectural barriers is the obligation to remove anything that prevents the patient with disabilities from fully accessing the provided services. So there are architectural barriers come in 3 or 4 or 5 main ways. It's whether or not you have handicap parking, whether or not there are curb cuts that allow you to go from the handicap parking to the sidewalk or to other areas, whether or not there are ramps to get for points of ingress or egress or elevators. And at those entry points, those ramps and the entry, ingress, egress to the elevators have to be at a certain slope, at a certain number of degrees, and they have to have the slope over a certain number of feet. Usually when we deal with these types of cases, and we get a fair number of them actually, because there are, as Andy mentioned, there are some serial litigants that go out and they drive to different places, try to access, have a problem, call up their plaintiff's attorney, and then all of a sudden we have the John Doe, 20th lawsuit about access, to a public accommodation. So the biggest thing is that if you're constructing, the big question always comes up is, when was the building built, and do you own the building or not? Owning it and not owning it doesn't. It's not like you can slough this off if you're a tenant and onto your landlord. There can be joint liability for it at times, whatever. But if you're the one that's holding out the services at the space, you can be put on the hook for it. So it's not something that if you're in the landlord-tenant relationship, you get out of. But also, when was the facility constructed? A lot of times we've made arguments and tried to successfully argue that, well, this is an older facility, it was built in the 70s, the 80s, the 60s, and which is prior to the ADA's advent in the 1990s. The duty and obligation, however, there's really no grandfathering in. So you do have a duty and obligation to have, certainly in all new constructions, but even in older constructions, depending on what the barrier is and what the issue is you may have to remediate it. If it's something to always plan for and to work into your budgets. And basically, as we talked about, it's with regard to path to travel, accessibility of medical equipment when you're within your space, on the inside of your premises, and also appropriate signage. A lot of times, not only you might be compliant, but a member of the population might not know where to go. So not only do you have to have means of ingress and egress, but you also have to have the proper signage. Back over to Andy.
All right, the Rehabilitation Act takes into account a lot of the issues that Kevin and I have been talking about, whether it's physical barriers, language barriers, the need for interpretation services, and so on. And we'll get into the website issues shortly. The Rehabilitation Act, it applies to recipients of federal funding, Medicare and Medicaid. And to succeed on a claim under the Rehabilitation Act, a patient has to demonstrate a bunch of things. One, that he or she is a qualified individual with disabilities, usually a pretty low threshold. That the provider is an entity subject to the respective statutes. Again, pretty easy to meet. Here's where the facts come into play, and that the patient was denied an opportunity to participate or benefit from the provider's services, or the provider otherwise discriminated against the patient by reason of his or her disability. Notably, as you see on the screen, you can't get monetary damages when you sue under the Rehabilitation Act. The exception to that, which by the way doesn't preclude you getting monetary damages under other codified law, the exception to that is if a patient can show that there was, and it's a phrase Kevin used earlier, deliberate indifference by the provider to the patient's rights. Essentially that there was an intentional violation of the rights. If there's mere negligence or gross negligence, you're not going to get monetary damages. So, for example, the mere failure to provide an interpreter under the Rehabilitation Act anyway, isn't going to suffice to meet that threshold unless you can show as a patient that the provider knew that there was a substantial likelihood that there would not be effective communication in the absence of the interpretation services. So like there was one case where, believe it or not, the staff were actually laughing off the demand of the patient for an interpreter, played it off as a joke, mocked the patient in certain ways. It takes pretty extreme conduct to hit that threshold. How do you minimize the risk of getting hit with these lawsuits and defending these lawsuits? As the next slide says, a bunch of elements. One is going to be, policies. What are your policies? Well, this is just who enforces it, private attorneys, and so on. But how do you minimize the risk? Okay. What policies do you have? What procedures do you have? What training do you have that addresses these issues, that gives your staff a roadmap on how to handle them? It's like Kevin was talking about earlier. We'll handle depositions. They'll say, what was your policy? Okay, fine. You give them a piece of paper, a document. Here's your policy. Then they'll ask your staff member, whoever's being deposed, walk them through step by step whether or not those, policy requirements were met. And they'll ask in detail. So you want to have policies that are actually implemented on the ground. One bullet that should be on here was documentation. Staff, to the best they can, needs to document these interactions. Kevin?
So, and what procedures, we talked about this a little earlier, I'm not going to belabor it, but basically you want early identification. Your procedures should put in place a structure where you're able to implement your policies. So your policies are your goals, they're what you're shooting for. The procedures put those policies into action, right? As Andy just mentioned, you want to be able to document. Documentation of the record, either a general memo to file that's kept administratively or something that's documented in the medical record, is always very helpful in these cases, because it does come down to a he said, she said. And when we represent providers that don't have documentation because they don't have policy and procedures at all, or they do have policies and procedures, but they weren't followed. But the good cases that we get, they had a policy and procedure, they followed it. And not only did they follow it, but they documented it in the medical record. They said, patient asked for this, we gave it to them. Patient asked for that, we did this. We got their informed consent. It was done for the interpreter. Next thing you know, we look at this and we say, wow, we're able to really there was effective communication and it was documented contemporaneously. And then the other thing too is it doesn't only stop with the interaction you have with the patient. Obviously, if you would do follow-up for other parts of the population, you should do it for this population as well. Coordinating healthcare, anything like that you would do for any other patient, you would do also here. The next thing you do is training. Training is really important. It comes up at depositions all the time. So you have the policies in place, you have the procedures in place, but did your staff know about it? Did you train them on it? All right. Do they have a sensitivity to these types of issues? Do they know what the policies and procedures are? And training is good both for the practical aspects of dispelling myths and understanding, like what needs to be done and what we're all shooting for. What's the common goal and what's the purpose of the ADA and the statute and what are we trying to do here? But it just raises awareness. It raises sensitivity. And a lot of times when we get complaints from members of this community, they just feel like that no one took them seriously. No one even cared to think about it one way or another. If you show through training and policies and procedures that this is something that everyone is focused on in your office, these claims are much less likely to come forward. And when they do come forward, they're much easier for us to defend. The other thing too is that do it when you hire new people. You want your new hire, work it into your new hire packet when they're filling out all their forms and everything, and they get the employee handbook and everything else. Make sure that you have a new hire training that includes this. And then also, it's great if you train someone when they're originally hired or whatever, but you should follow up periodically every year or two with follow-up training to make sure that they remain sensitive. Next thing we want to move on to is website accessibility. This is the third area, and as we mentioned, this is the hottest and newest area where we're seeing the ADA lawsuits proliferate. You have an obligation to make your website accessible to the disabled. And what does that mean? it's not only the content, as Andy mentioned earlier, but it's also the ability for, in particular, patients who are either blind or who have visual impairments, their ability to interact with your website as a portal or as a gateway or an entranceway to services that you provide. So there's basically things you have to do with regard to your website, and there's standards with regard to it. But we just want to give you a little bit of an idea as to how these lawsuits have exploded in the last 2 to 3 years.
Right, so we're going to skip to slide 36. Why should you care? These next 3 slides essentially just show you in pretty colorful terms that in the last 4 years, the number of lawsuits filed in these website cases has gone from 800 plus to well over 4,000, actually in a 3-year stretch. So as Kevin says, the surge continues on a year-to-year basis, and with the increasing use of communications between people everywhere using their computers and the internet and so on to communicate with people, we anticipate even greater numbers in the years to come. So why should you care, right? Well, one, if you don't comply, it's going to lead to litigation with its attendants, legal fees, and other costs, and even responding to demands letter can cost you a whole lot of money. You have serial plaintiffs. You have a couple of examples on there. One, she filed 250 lawsuits, right? 114 in New York. Same person making the same claim. I couldn't access the website. Another one, 500 lawsuits across the United States. Same individual. Because basically what they do, without exaggeration, without much exaggeration anyway, is they'll go from entity to entity. They'll go to your website, they'll go to my website, they'll go to Kevin's website. They'll test out the same different issues and trying to access, and we see the same complaint being drafted with sometimes in the most obvious sloppy cut and paste ways against dozens of different entities. When one of our clients gets sued, first thing we do, we go online, we access the court databases, we enter that person's name, puff. We had one recently that we resolved. There were 18 lawsuits filed by the same plaintiff. It's abusive, it's annoying, but in some ways helpful because you realize that the plaintiff's attorney in that case is not in it for the long haul necessarily, so it helps inform you tactically on how to deal with them and get rid of these cases to the extent you can at pretty low value. So you have litigation expenses, you have government investigations that could come from this and potential civil penalties, all right? While the ADA, as I mentioned before, doesn't generally, does not allow for compensatory and punitive damages, other codified laws does. Attorney's fees are the real hammer in these cases. Kevin and I have handled website cases, we've handled the accessibility cases, that we've described earlier. And it's one of those instances where the more aggressively you litigate, because the merits, you take an objective view and you go, this is contrived. The person wasn't coming to my healthcare facility. They're just suing me because my website has a flaw. The more aggressively you litigate, the more you drive up the attorney's fees of the plaintiff, and the back end, if any liability is found, maybe you're only paying a little bit in terms of compensatory damages under whatever the codified law is, but the attorney's fees are going to be, the great weight that you have to deal with. Fortunately, when it gets that far down the road, Kevin and I have been in those back rooms with judges and plaintiffs' counsels. They will literally go entry by entry into the legal bills of a plaintiff's attorney to cull out what is a whole lot of fat in them. And I'm speaking generally, obviously, not in any across the board way. But those attorney's fees can be pretty painful. And so, what do we do when we get these cases? What we tend to do with the website cases is we sit down with the client, we pull in an IT vendor. What are the problems? What are the flaws? Get it compliant as soon as possible, fix what's broken, and then you streamline the case and reduce it to a monetary damages situation. How much is this case really worth? And Kevin and I have used that tactic with great success in driving down the market value of these cases. But that's a pragmatic approach to things. Kevin?
A lot of first thing, and I want to be cognizant of time because we're right on schedule, where we might be a little bit behind. Is that um, clients come to us and they say, my website's fine. I spent a lot of time on it. I spent a lot of money on it, and I want to fight this lawsuit. As Andy just said, while there can be damages in these cases, the biggest thing is the attorney's fees. The you, you, there's two big things that wind up being it's the money that you put into fixing and remediating your website, and paying attorney's fees not only to your own attorney but paying attorney's fees to the other side. There were two very highly publicized cases, Gilvey Winn-Dixie stores. Many of you may have heard of it. Also, Robles versus Domino's Pizza. I'm not going to get into the nitty-gritty of these cases, but these are basically Winn-Dixie, which is a large retailer down south in Florida and throughout the South, and Domino's, which everyone knows Domino's Pizza. They decided to dig in and fight, and they paid hundreds and hundreds of thousands of dollars in attorney's fees and hundreds of thousands of dollars remediating their websites because they decided to dig in on it. And many in the legal community are questioning whether it was the right move for them or not. Very often with these cases early on, to broach the idea of settlement or resolution makes a lot more sense financially. So how do you decrease your chances of being sued? Basically, there are standards. They're called the WCAG 2.0 standards. And it's what the courts follow, it's what the Department of Justice follows, and it's what attorneys follow. They have certain goals, and then they have certain guidelines. And basically, they're accepted throughout our country and in other countries. It's an international consortium, and you're looking to shoot for any vendor that works with you on this or any attorney that works with you on this. There's A standards, AA standards, and AAA standards. You want to be at the AA standard. That's the minimal level you want to be at. You can be at AAA, but you can never be at A. And it goes in and out of everything you need to do with regard to your website accessibility. There's 4 principles that they look at in each one of the guidelines and protocols for your website, whether it's perceivable, whether it's operable, whether it's understandable, and whether it's robust. And we'll speak briefly about each one of these. I'll turn it over to Andy right now.
2 points. One, there's still some questions on the board. We'll take them at the back end for everybody. And the other is just to highlight what Kevin's saying, is that you really should, with an IT expert, if it's in-house or an outside vendor, audit your entity's website to ensure compliance with the WCAG standards and make appropriate changes as guided by those IT professionals, and then conduct annual audits to ensure that there's continued compliance. As part of that, include accessibility issues as part of your website and strategy. And when new technologies are implemented, when you update your system and so on, part of that process should include the implications for persons with disabilities. Okay, so Kevin, walked you through the 4 main principles. With regard to, we're going to move to slide 43. Perceivable. What does that mean? It means that information and user interface components must be presentable to users in ways that they can perceive. And this particular principle ensures that content is available to view in multiple forms and is easy to see or hear regardless of one's disability. So for examples, it might be putting an all text tag on an image, or providing captions for all media content. Certain design adjustments you may want to consider with regard to the perceivable, facet. Add text to your images. Many websites contain images. However, if there's no text to identify the image, a blind person, a visually impaired individual, screen reader, is not going to be able to identify that image. And the user would not have any way of knowing if the image is a logo, is a link, or to another page, or simply a stock photo. So for example, let's say you had a governmental website that has a picture of the governor. The visually impaired person should be able to use their screen reader to go over the image and hear photo of the governor. And again, these are just examples. I'm not going to go into greater depth than that, but these are the kinds of issues that your IT vendor is going to look at. Operable, whether the user interface components and navigation are operable. And this principle ensures that a user can easily navigate your website without running into limited functionality or time limits. You know, one example, can the user navigate through this site using only their keyboard, you know, which would be a helpful component. Whether the user has the ability to pause scrolling information, whether your web pages are titled with a topic or purpose. All right. Again, just examples. We're bulleting through them because this is a little more technical rather than legal. How do you do things on a day-to-day? How do you respond on a day-to-day? Understandable pretty much is what it sounds like. You know, is the text readable and understandable? And this ensures that people have the capability to even correct their mistakes, as you see on the screen. You know, are there instructions on the screen that will help somebody navigate? And finally, on the next slide, is the website robust? The content must be robust enough so that it can be interpreted reliably, again, by a wide variety of users, including those, you know, who have disabilities. So you want to allow for adjustments in color and font size. You want to enhance your multimedia just by way of example. So, for example, web design is often designed in such a way that doesn't allow the user to adjust font size or color. This is just to help them protect their brand, but they're also inhibiting some users. For example, visually impaired individuals need to use high contrast color settings or very large fonts to read a website. But if they can, then their ability to use your website is going to be impeded. So again, I don't want to get too granular on this. Your IT expert will be able to walk you through it, but these are some of it's really to give you a sense of, wow, I really should take a look at the website and make sure that those 4 components are satisfied. If we go to slide 51.
Yeah. So now, how do you ensure compliance? You do it from the start when you first create your website, but many people already have up and running websites. If you already have an up and running website, what you need to do, as Andy mentioned earlier, is you retain a vendor. Vendor will assess whether or not you're in compliance with the WCAG standards, and then they'll make an assessment. Some of the fixes can be done right on your website, and they can be done cost effectively, so you should do that. However, there are other things that you can do. There are like kind of quick fixes that are offered by third-party vendors that kind of overlay your website, and they're like a veil or like a widget that kind of like interprets your website for the end user. These are a little tough. Some people have had some limited positive experiences with them, but sometimes our clients wind up having issues with them because they don't. It's basically a third-party vendor interpreting your website. And then trying to translate it for, so you have to really test that if you're going to do any testing with or any use of that going forward. Why do you want to comply? If you don't comply, as we mentioned throughout this, there can be injunctive relief that's going to force you to comply anyway. You're going to have to fix your website and spend the money. The biggest thing in the ADA cases is the assessment of attorney's fees. Not only do you have to pay your own attorney's fees, but you have to pay for the other side. As you know, in our country, you typically don't pay attorney's fees for the other side unless you agree to do it in a contract or unless there's a statute. And here there is federal and state statutes that shift attorney's fees. And the reason why the government has done that is because they're looking to root out issues with regard to provision of services and accommodations to this community. You can also have compensatory and punitive damages under certain state laws, and there's also civil penalties by DOJ. And those penalties start at, I think, $75,000.
Right.
So if you get a demand letter or if you get a lawsuit, get an attorney right away. That's not only a pitch to call up your friendly neighborhood Garfunkel attorney, or whether it be me or Andy or someone else, but seriously, it's very important. And you need that to assess the situation. A lot of these are handled and settled very early on. A lot of members of the community that have disabilities, they are not looking to make a federal case out of it. They're looking to get access, and they're looking to get the services for themselves and other similarly situated individuals. If you deal with them with the utmost care and respect that you would with any other patient, which which I'm sure you do in the normal course of business, you wind up, you can head a lot of these off. And we're successful mediating these and speaking with people and showing that the care and concern that our clients have for these realities. And you don't have to have a lawsuit. You can deal with it at a demand letters phase, and it's usually very much more cost effective as well. And obviously it's the right thing to do. That is it. We'll now turn it over to questions. We have a couple in the queue here we can deal with, and we want to thank you very much for your time today.
Yeah, one of the questions is, what do we do when a parent comes in with an adult disabled child aged over 18 and the parents talk for that individual, but there are no legal documents indicating that the parent, it says, has power of attorney. If you don't have the right documentation in place, healthcare proxy, et cetera, then aside from the issues Kevin and I are talking about, you may have malpractice issues in terms of informed consent if you're not sure that the individual has authority to speak on behalf of that adult disabled child. So just you have to have that documentation in place. Another question, does what Kevin and I were talking about today in terms of access of various types to medical services, does it apply to a patient portal? The answer to that question is really all of what Kevin and I taught. The answer is yes, short answer, but it's really, is there going to be a level playing field if a patient without any disability is given access to your services? You have to ensure that a patient with disability has the same access. So if there's a portal that you have patients use, then you got to level the playing field, whatever form that may take. Another question.
I can jump on that just for a second. The newer cases now, and Andy knows this too, we've shifted not only from websites, but to apps. So apps, portals, any other sort of and the WCAG 2.0 to 2.1 to 2.2 guidelines are now picking up to the extent that they've become more robust. They've pulled in the mobility and access points from not only the traditional desktop, but also from mobile phones and from smartphones. So the answers are a very resounding yes. The legal standard, without getting too technical, is if it serves as a gateway or a portal to the services that you provide, which inevitably it usually always does, you have to provide in a fashion that can be used by the members of the community. Sorry.
Okay. We otherwise want to thank everybody. Those whose questions we could not answer, feel free to reach out to Kevin, reach out to me. We'll do our best to help you out. Otherwise, like Kevin said, we thank you for today, for staying the course, as we say, and giving us this time. Have a great day.
Thank you. Thank you, everyone. Thanks.
Bye-bye.